Hello aspirants, this is Shravani Ram. Welcome to Prime Time. In this video, we are going to see all the important current affairs of polity and governance from 7th of October to 13th of October. So we have 4 topics in brief and one editorial topic as a topic of importance. So let's get started. The topics in brief are passive euthanasia. In this topic, we are going to see what is passive euthanasia, what is active euthanasia, what is vegetative state and living wills, and what are the related case regarding the passive euthanasia, and what are the reforms expected, and how it is related to Article 21 and 226, how we are differing from Britain. All the things we are going to see in the first topic. And next topic is NAKSHA Programme. What is NAKSHA Programme? What is initiative? Why it is in use? We'll have a brief details regarding it. And what is the announcement of Nobel Peace Prize 2025? We'll see who will award that and what are the related details regarding it. And eligibility for the district judges. But the court has recently said the new update regarding the eligibility of district judges. We'll see in detail. Coming to the topic of importance, it is an editorial topic regarding demographic mission. How we can term demographic mission into holistic approach. We'll see in detail. The first topic is passive euthanasia. So, this is an editorial topic. It is in news because the UK's terminally 3 adult end of life bill has came into execution. This led debates on the reforms of passive euthanasia in India. So, before knowing what is passive euthanasia, we have to know what is vegetative state, what are living wills, and what is passive euthanasia and what is active euthanasia. So, coming to first, vegetative state. It is a state that it is a medical condition, there is no scope of recovery. They'll be having some brain functions but no physical activities, physical movement. They'll be alive with medical support. So, this is vegetative state. There is no hope of recovery. Coming to living wills, a living will also called as advanced medical directive means when they are healthy, they'll give the directions regarding when they are completely ill, vegetative state, or they are incapacitated to respond. So, before they are giving regarding the directions regarding the medical treatment, that is called living wills. Coming to passive euthanasia, stopping the medical support to the vegetative patient, allow them to natural death. It is called what? Passive euthanasia. Coming to active euthanasia, we are giving drugs to end their life. Means maybe use of injections, maybe use of some medicines, we are allowing them to die. So in India, we can practice only passive euthanasia under certain special conditions, but active euthanasia is illegal in India. So in this perspective, what are the relative cases behind it? First case is Aruna Shanba case of 2011. She was in vegetative state for the 42 years and end her life. In this case, the doors were opened by the court for the passive euthanasia in India. The second case is in 2018, that was a bill. So that is Common Cause versus Union of India. In that case, the questions asked to the court was, does the right to life under Article 21 includes right to die with the dignity? Does the passive euthanasia has a constitutional validity? These are the questions before the court, and the questions answered were, even in this case, the court has opened and given some rules for the practicing passive euthanasia. And the court has also accepted living wills for performing passive euthanasia under certain framework. Even it has enabled that the power has enabled with the high courts under Article 226. That is nothing but filing writ petitions to High Court. So, and also reforms made in 2023 means some regulations made regarding the framework. But there is no constitutional legal work up to now. So, these all are done by the Supreme Court verdicts. So coming to the articles, Article 21 and Article 226, that is nothing but filing writs in the High Court, are important in this perspective. So coming to the Britain bill, how it is different. In Britain, it is they are performing active euthanasia also. But in India, we are not allowing active euthanasia. We are allowing them to natural death by using passive euthanasia. Okay, so that is the major difference between the Britain's bill and in our India. Our next topic is NAKSHA Programme. So why this is in news? Because there is a 2 days workshop is going to be conducted by LBS NNA for district collectors regarding the NAKSHA program. Even the Ministry of Rural Development is also part of it. What is NAKSHA program? It is a landmark step towards digital urban land governance. So NAKSHA means mapping. So they are digitalizing all the urban area. When there is a initial pilot program, they are initiating in 28 states and 3 union territories. So this initiative comes under Digital India Land Records Modernization Program, that is DILMRMP. So the aim is digitalizing the urban locations, urban area. So the idea is one nation, one land record. So it gives more transparency and it will enable the property taxation make easier. In this NAKSHA program, the technical tools used are GNSS, Global Navigation Satellite System, and they are using web platforms to map the urban land records. So it is initiated in 28 states and 3 union territories. Our next topic is Nobel Peace Prize of 2025. So this is awarded by Norwegian Nobel Committee, and rest of the all Nobel awards are awarded at Stockholm. But the only Nobel Peace Prize is awarded in Oslo, and it is first awarded in 1901. Over 300 nominations this year awardee was Maria Machado. She often said, democracy is not a luxury, it is a right and we have to fight for it. She is born in 1967, Caracas, Venezuela, and she is trained as an industrial engineer. And she is often active as a political leader from 2013, and she has served the National Assembly from 2010 to 2015. She was awarded the Nobel Peace Prize because of her peaceful struggle towards democracy and human rights in Venezuela. She dedicated this award to every citizen of Venezuela. Even Trump has nominated to this award, but the committee did not mention reasons for not shortlisting the Trump. Our next topic is eligibility for district judges. It is a recent verdict delivered by a Supreme Court. It was a 5-judge bench, constitutional bench. So what it said is, who has the judicial officers, means who is presently serving the bar, who have 7 years experience at bar, are eligible to be appointed as district judges and additional district judges. So they are combining 7 years. Before that, it was consistent 7 years. Fine. So what is the criteria now? Combined minimum of 7 years of experience as an advocate. And the remaining criteria will remain same. The minimum age to set is 35 years, and it even guided the state government in consultation with the high courts make rules according to it. Our topic of importance is holistic demographic mission. So it is an editorial topic we are seeing. So this demographic mission was introduced by the Prime Minister Modi in his Independence Day speech. So what are the holistic approach of it? We'll see in detail. So the population dynamics includes what? The migration, human capital, aging, equity, and socio-economic conditions. So to balance all these things, what we are using is institutional architecture and policy coordination to guide inclusive and sustainable development. So let us see what are the core components of it. So data and demographic intelligence that covers mortality and fertility, capability, rights and security, migrations, all the data and demographic analyzation. And according to that, to improve our human capital, we need to make according policy frameworks and institutional mechanisms, and safeguards and rights protection is also a core component of it. Public participation and communication, like surveys we are doing it on it, monitoring it, accountability and targets. What are the risks involved in it? We'll see in political overtones, it may be political overtones and privacy issues, because we are taking data and that surveillance is also very important. And federalism jurisdiction, it is related to rights of individuals. And resources, the resources has to be confidential and liable. And capacity constraints, political backlash, I repeat, political backlash and implementation gap. Always there is a failure between the data and policy making and implementation. This has to be what erased. And institutional, coming to the institutional frameworks, we are doing it through what? We have national population registers and national family health surveys and migration policy. This has been just proposed, not yet implemented. And ministries like the ministries involved are health ministry, women and child welfare ministry, and rural and urban development, and labor and state governments also involved in it. So if we can balance these challenges and co-components through the policy work, then we can achieve the holistic demographic mission that will increase our human capital. So now let us see what are the previous year questions. The first question is, it came in 2016 UPSC Prelims. With reference to the writs, consider the following statements. The writ jurisdiction of a Supreme Court is narrower than that of High Courts. So, yes, the writ jurisdiction of Supreme Court is narrower than that of High Courts. High Courts has a broader writ jurisdiction. So, this is true. And the territorial jurisdiction of Supreme Court is wider than that of High Court. Territorial extent is always wider. Why? Because Supreme Court involves all the states and union territories, all the parts of India. But whereas High Court, it is limited to one individual state. So, territorial jurisdiction is wider for Supreme Court and writ jurisdiction is wider for High Court. So, both are correct. The answer is A and B. Coming to the second question, it is 2017 UPSC prelims question. Consider the following statements regarding Supreme Court's writ jurisdiction. The original jurisdiction of the Supreme Court with regard to federal disputes is different from its original jurisdictions with regard to the disputes relating to fundamental rights. It is different. The both has a original jurisdiction. Regarding federal disputes also, regarding fundamental rights also, Supreme Court has original jurisdiction, but it is different. In case of first case, that means it is talking regarding federal disputes. It is exclusive, and in the second case, it is concurrent with High Court's jurisdiction. Yes, coming to the federal disputes, the court that only can solve is Supreme Court. You cannot approach the High Court. So, this is also true. Coming to the fundamental rights, High Court also you can file a original jurisdiction. So, A and B both are right. Answer is C. And next. The next question is, it came in 2018 UPSC prelims. Consider the following statements. Supreme Court can refuse to exercise its writ jurisdiction. No, it cannot. It cannot deny. So, this is wrong. The writ jurisdiction of Supreme Court is wider than that of High Court. No. For writ jurisdiction, the High Court has a broader, wider case. So, this is also wrong. The answer is neither A nor B. Coming to question number 4. It came in 2024 UPSC CAPF exam. It is also prelims. Which of the following statements about the Nobel Peace Prize for 2023 are correct? The 2023 Nobel Peace Prize was awarded to Nargis Mohammadi. Yes, that is true. Nargis Mohammadi was awarded the prize for her struggle to bring peace in Afghanistan and Iran. This is wrong. Not between the peace in Afghanistan and Iran. She fought for the human rights and women rights in Afghanistan. So, and the fifth question, with reference to the Nobel Peace Prize 2020, consider the following statements. The World Health Organization was awarded the Nobel Peace Prize in 2020. The Food Programme was awarded the Nobel Peace Prize in 2020. Which of the statements above are correct? The both are correct. So answer is A and B. Coming to the mains question. This came in 2021 mains examination. Right to life include right to live with human dignity. In the light of the statement, discuss the constitutional validity and significance of Supreme Court's recognition of passive euthanasia in India. So first, introduction, define Article 21 and importance, evolution of Article 21 means interpretation, and link this to common cause versus Union of India case. Judgment means how it is expanded that even right to die with dignity is also part of Article 21. You have to introduce that. Coming to the body, you need to address constitutional validity. By what? You need to discuss the expansion, evolution of Article 21 using cases like Aruna Shanba case of 2011, even common cause case in 2018. Okay, you need to discuss even 2023 reforms and significance you need to discuss. And then you mention the criticism like misusing of it, judicial overreach and lack of legislative framework, because only it is doing by what? By the court's judgment, but there is no legal framework by the legislature. You need to address it. And then in conclusion, you need to give the way forward, how to achieve the better way in what are the reforms you would like to mention in regarding the passive euthanasia. Please send your answers to response@civiccentre.in. Hope you find this video helpful. Thank you for watching.